I'm batting 1,000 so far. Okay, well, our first case today for the 9 o'clock is 18-3505 Hall versus State of Florida. And with that, the appellant can let me know how much time you'd like in rebuttal. And
5 minutes, please, Your Honor.
How much?
5 minutes, please.
5 minutes. And counsel, you may begin when you're ready.
Thank you very much. Good morning. May it please the court. My name is Maria De Liberato, and I, along with my co-counsel, Mari Louise Samuels-Parmer, represent the appellant Mario Hall. Mr. Hall was convicted and sentenced to more than double the bottom of his sentencing guidelines after a jury trial where more than 60% of the state's case consisted of pervasive, speculative, and improper opinion testimony about the generalized practices of drug dealers. The more than 9 hours of expert testimony came from a law enforcement officer and from a self-proclaimed master of the drug trade, 11-time convicted felon Arthur Wilkerson. This testimony went far beyond the scope of permissible expert testimony, improperly invaded the fact-finding province of the jury, and directed the jury to find Mr. Hall guilty based on the conduct of other drug dealers in unrelated cases. And so if you take a look at the state's case here, there was no direct evidence of Mr. Hall conducting any hand-to-hand transactions. There was no poll camera footage. There was a poll cam. The footage was inexplicably destroyed. Mr. Hall was in custody for more than half of the time period that the wiretap was active. He was not at the house when the warrant was served, when any of the drugs were found. He was never found in possession of any drugs. There was no fingerprints on any of the items at the house belonging to him. There were, of course, fingerprints belonging to the co-defendant. He was convicted solely based on the testimony of cooperating co-defendants who all received deals and this improper opinion testimony. And established case law in Florida tells us that this kind of testimony can be admissible in limited circumstances. And the argument here, of course, is that the testimony far exceeded those limited circumstances. The sheer number and amount of testimony from Agent Noto, he was on the stand for 8 hours. The state's entire case was only 13 hours. Arthur Wilkerson was permitted to testify to completely speculative things, including the fact that because Mr. Hall left his cell phone at home when he went into jail, that automatically meant that he intended for the operation to continue.
Can you address the preservation of the argument you're making now in regard to the testimony? I'm sure you saw the argument that the objections were based on speculation, and on appeal, it appears you're making a relevancy objection. So could you address that?
Certainly. And so I think if you look in my reply brief, I cite all of the times counsel objected more than 15 times to Agent Noto, and he objected to speculation, to lack of foundation. He also objected to the subjective part of Noto's testimony as to what Mr. Hall was thinking, and that it was outside the scope of the expert opinion. And that's page 123 of the ROA. So I do think that if a fair reading of counsel's objections, which were repeated, do include outside the scope, do indicate overly prejudicial. The court was clearly on notice that this testimony was problematic. In fact, counsel requested a standing objection. And so I think specifically when counsel is objecting to Noto's comments about what Mario Hall must have been thinking by using this language, that's really where the problem is. And an example, I think, to that can be found at page 180, 181 of the record, where there's a particular call where the caller says, "Hey, I got stamps. Can you do something with that?" And Agent Noto was permitted to testify that what is happening in that call, all it says is stamps. It doesn't mention food stamps. And Agent Noto was allowed to testify that this male had food stamps of $160, and he wanted to trade Mr. Hall in exchange for drugs. And he said, usually in this type of situation, in my experiences, they usually get 50 cents on the dollar or whatever amount. That at that point, counsel objects, the same objection overruled. And so it's that idea that he's objecting to what Agent Noto is saying Mario Hall must mean by using this drug jargon. And so
well, counsel, there's two questions there, right? So doesn't trial counsel have to raise the right objection? It's not enough that trial counsel just objects, right?
Sure. I think the law
Well, I
says
guess
the court
so. The
has to be.
question, Judge Sasso's question is, did trial counsel raise the right objection?
And I think the answer is yes, that a fair reading of this record shows that he objected repeatedly to improper speculative testimony. And that's the
But
argument.
that's not your argument. It doesn't seem like your argument on appeal is based on speculation, right? Is your argument on appeal that it was improper speculation?
The argument on appeal is that the testimony, it was improper expert opinion testimony, which counsel objected that it was outside the scope of expert opinion testimony and that it invaded the fact-finding province of the jury. And so I think if counsel's objection that this is outside the scope of permissible expert opinion testimony, that is along the lines of the argument that we are making in this appeal, that because of the sheer number and nature of this testimony, it invaded the fact-finding province of the jury. It directed the jury to find Mr. Hall guilty based on this improper expert testimony.
Now, you also mentioned testimony regarding jargon or code, right? Is it error to allow an expert to testify regarding code language that might be used?
So, I mean, certainly it is admissible, and this court and other Florida courts have held that it can be admissible in limited circumstances to explain certain things to the jury that would be outside their usual form of knowledge. In a lot of the cases that are cited—
The example that you raised, wouldn't that be a good example of an expert explaining jargon?
So I think in that case, no. I mean, there has to be some level of corroboration to the actual organization. So if you look at the cases where the court has found it to be permissible, the testimony is coming from people in the organization who are using the jargon and linking that specific jargon to that specific organization. So interestingly, I mean, Ms. Roberts, a co-defendant here, testified against Mr. Hall after getting a deal for her participation. She wasn't the one that was talking about the jargon. It was all Agent Noto based on his generalized practice in Arthur Wilkerson. And so in the cases cited by the state, United States versus Delva, for example, the officer was allowed to testify as to the jargon that particular organization used, and it was corroborated by other members of the organization using that same jargon. So the argument here is we just don't have that same link. So certainly I'm not disagreeing that this kind of testimony can be admissible in limited circumstances.
Do you have a case supporting your position that it has to be testimony from someone inside the organization?
Well, I mean, I don't think there's a case that says per se it has to be that, but if you look at the cases where the court has found it impermissible and you look at the cases where the court has found it permissible, that's the distinguishing factor. And the court has in the past found it permissible when it is linked, when there's corroborative and other direct evidence linking it to that. And again, if we were talking about an isolated incident, one or two comments, I may have a very different argument, but this is 8 hours of testimony. And so in the case law, the reason that it's wrong, the reason that it's been reversed in other cases is because it goes directly to the heart. It invades the fact finding of the jury. And so the Florida Supreme Court has said repeatedly that juries have to convict the defendants based on the conduct before them, not based on the conduct of other criminals in other cases. And that's just really what happened here with Mr. Hall's case. And so, I went through the example of the food stamps. There was another example that's set forth in my brief that's pretty egregious in terms of cleaning supplies. There's a simple text that says you want cleaning supplies, and Agent Noto was permitted to testify that—
Again, though, so I think you just kind of hit it on the head. So the issue that you're arguing on appeal with this testimony is that it invades the fact-finding province of the jury and is overly prejudicial. That is not, I guess your argument is that by saying that it exceeded the scope of an expert opinion or was improper expert opinion, that puts a trial court on notice that the testimony is unfairly prejudicial and exceeds the fact-finding province of the jury.
Yes, and that's based on counsel's more than 15 objections during Agent Noto's testimony.
And how many of those 15 objections were speculation?
So what happened was counsel had made the argument about speculation, about outside the scope, about the testimony making it subjective to what Mr. Hall was thinking. He asked for a standing objection, which of course is not sufficient to preserve. So every time he just stood up and said, same objection.
Okay.
So, I mean, it appeared from the record that the court did not allow, it's a jury trial, did not allow speaking objections. So, but a fair reading of his initial argument, his initial objection request for the standing request, it is our position that it is properly preserved in the way that we argued it before the court.
And based on your understanding of the record, was there ever a relevancy or overly prejudicial objection specifically made?
I do believe that he made the irrelevancy objection. I don't have the site off the top of my head. I don't agree. I don't believe that he did specifically say prejudice outweighs any probative value. But he did say outside the scope of expert testimony and improper opinion testimony repeatedly for both for Agent Noto and Mr. Wilkerson.
I mean, counsel, that's a pretty generalized objection, isn't it? To just say it's improper. I mean, isn't every objection based on something being improper?
Well, I don't think it was that general. I mean, again, I think if you look back to page 123, where he's objecting to the subjective part of what Mr. Hall is thinking. And so really that goes to the crux of the argument that we're making here, that the reason this testimony was improper was Agent Noto was allowed to say all of this happens in other cases. And so that must mean what Mr. Hall was thinking here. And, you have also the problem of Agent Noto is a law enforcement officer, right? So he automatically, we know, despite the jury instructions, that he carries more weight with the jury. And then he's conferred this level of expert. So he's effectively a super expert, right? He's a law enforcement officer, and that carries a lot of credibility with the jury. He testified for more than 8 hours, and he's allowed to testify to this expert opinion. And so that, coupled with the other testimony and the lack of direct evidence against Mr. Hall for this racketeering operation.
Counsel, is there a difference between Noto testifying regarding what sort of code, what phone calls mean, what may be considered code? Is there a difference between that and, say, when he testified that drug dealers don't put their garbage out on the street, and that's what the defendant did here, things like that?
I think there can be a difference in both. I think they're both problematic for different reasons. I think some of the testimony about the trash in the street and the pit bull in the yard, and they change phone numbers and that sort of thing, and stealing laundry detergent for drugs and food stamps for drugs, it really sort of plays on stereotypes and has a lot of improper inferences to the jury that way. But anything that Agent Noto was actually able to link to Mario Hall's activities, I think I would have to concede that there is more relevance to that, right? If he says this is something that's done and this is something that Mario Hall did, it's a little bit of a different argument than this is what drug dealers do. I still think it's problematic, primarily because, again, of the sheer examples, and that this was not a case where they had solid direct evidence in Mr. Hall.
You think the testimony that drug dealers don't put out their trash, and that's what this defendant did? Drug dealers have pit bulls, and that's what this defendant did. Drug dealers change their phone numbers, and that's what this defendant did. Do you think that's less problematic than interpreting the code language?
I think I didn't mean to say that it was less problematic. I think they're both problematic, but at least there's a link. It's still speculation, and it still leads the jury to conclude that because drug dealers did this, therefore Mario Hall is a drug dealer, absent any sort of direct evidence of him selling drugs to a particular person or being in possession of a tremendous amount of the amount of drugs that were found, since he was obviously in custody at the time that this warrant was served. So I think that I didn't mean to imply that was less prejudicial. I think that they're both equally problematic.
So your basic position is that, look, if law enforcement can't find, or if the state can't find a witness on the inside of the organization who is willing to testify that, yes, stamps means this and come on means that, right? The defendant is recorded numerous times saying, come on, right? Come on by. And that's all he says in the entire phone call, kind of thing. Your position is that the state can't find a witness who's willing, inside the organization, who's willing to testify what that code means, then the state can't present any evidence in that regard?
Well, first of all, they had a witness and they had a testifying witness.
No. My question is simply, if the state can't find an inside witness, they're out of luck. Yes?
I think the state has to play by the rules in order to get a conviction and proof beyond a reasonable
what if
doubt.
there's code that is used in the entire community, not just one organization, right? I mean, that could be, right? Is it impossible that there is code language that's used uniformly in a community?
I mean, they would have to establish, the state would have to establish the community and establish that they would have to sort of meet the evidentiary requirements for that.
Could they do that through an expert, not inside the organization?
Potentially, but they didn't. But in this case, again, in this case, they didn't do that. And in this case, we're talking about, this is the crux of their case. I mean, the state comes back to this in closing argument. I mean, we know the reason that they put on this evidence was because they lacked the direct evidence in order to convict Mr. Hall. So they relied solely on this testimony. I do see that I'm into my rebuttal. I'm happy to answer any questions. Otherwise, I'll reserve the remainder of my time.
Thank you, counsel.
Thank you.
All right. And counsel for the state, whenever you are ready, you may begin. Counsel, we can't hear you. Now you're muted. You were unmuted, but we couldn't hear you.
How about now?
There you go.
Oh, very good. I'm sorry.
Could you start from the beginning, please?
Yes, Carmen Corrente, representing the state of Florida. And as to this issue, we could look at it at another angle as well. We've gone over pretty much. Well, first, the state would like to mention that the background information, where he said drug dealers use pit bulls, drug dealers burn their trash, as has already been mentioned. Drug dealers use cameras. Drug dealers change their cell phones. There's no objection to any of that. That testimony went through 10 to 12 pages of the record.
Have there been an objection? Should the objection have been sustained or overruled?
Should have been sustained, I would believe. I would think that that's, well, it's what drug dealers do. It hadn't been attached to this defendant yet, and it would be within his expert testimony. But then he does connect.
But somebody changing their phone number doesn't mean they're a drug dealer, right?
No, I know somebody who burns their trash. I did that for a while.
Just because you have a pit bull doesn't mean you're a drug dealer, right?
Exactly. Exactly. No, it doesn't. The testimony from the expert is that often it's that way. But even so, there was no objection to any of this. And then it came into, now we've got videos, and the Perez case comes into play where they're using green, transformers and you know, all of the green monkeys, I guess it was, and transformers and things that no juror would know. And if, for instance, the expert was not allowed to testify as to what stamps were, the jury would probably infer they were food stamps, postage stamps, green stamps. I mean, they would know it's something of value. The angle the state would present, especially in the brief, is it's harmless error, no matter what, because in all of the cases that they're relying on, this is testimony that damned the defendant, and it was very little evidence. There was one deal, maybe two deals in the dark, officers' testimony against the defendant and any cohort. We've got 1 month, 3,000, almost 3,000 phone calls, a huge investigation here. There is no
counsel,
mistake.
without Noto's expert testimony on what all those phone calls meant, there wasn't a lot, right?
Well, the code and the jargon was necessary to explain it, but they didn't need to, the jury didn't decide this on the fact that he had pit bulls or that he burned his trash. That was the only testimony that was extracurricular to an actual drug deal. What is he saying in here when someone is asking for green monkeys? What does he mean? That's what he is able to testify to. That's important. The jury would have no idea what we were talking about. It's the substance of the charges. The charges were green monkeys were MDMA, and we can't prove MDMA without explaining that. And we can't prove that count.
Did you, counsel seems to suggest that you probably needed an inside witness to explain this particular organization's jargon. What do you say about that?
No, he testified that he had sat in on thousands of calls and knew the lingo and was familiar with it. And that's the same as being inside the organization. If you're wiretapping their close, intimate calls and conversations, you're in the organization. I think it would qualify in either way. And again,
what about the testimony where he sort of just blurted out that there had been a prior hearing in a different case, and that the videotape had not been destroyed in bad faith? Well, was that improper?
No, it was not improper. It was all set up by the defense in their cross-examination. The state properly handled the direct, and the defense wanted to make, and rightfully so, I understand that, defense attorney for 12 years, rightfully so, wanted to make a big deal out of the fact you lost poll camera footage. You're inept, you're incompetent, you don't know what you're doing. Didn't you want to know why that happened? And this is a witness who said, yeah, I did. I checked with our tech people. We had a hearing. It just came out.
Well, he could say, look, I mean, I checked with our tech people and it was a tech glitch.
He could have, but he
could have said any of that, but why? I mean, how was it proper to say, oh, and by the way, another judge in another case already looked at this and said, hey, everything's fine?
Well, now that wasn't said. It was just said, we had a hearing and it was cut off right there. Jury was not aware of any of this. The defense attorney was fully aware that they'd already had a hearing and what had been determined at that hearing, and he still pushed that button. All the judge did in this case was allow the state to ask one question to clarify that, so the jury wasn't misled about there was another hearing and, oh, there could have been malfeasance or wrongdoing, and there wasn't. The defense, in my estimation, could have stopped one question before, instead of grilling him that it was his fault that the poll camera footage, which he said, I'm not a technical person, I don't know.
I'm just curious, what exact question did defense counsel ask that invited the witness to bring up the prior hearing? Because I was unclear. I didn't see any questions from defense counsel that invited that.
I believe it was in my brief, and that I cited it. I mean, actually copied it out in the facts. If you give me one moment, I'll try to see if I can find it without making too much noise. Which issue was this? Was this issue 2-1B? Yes. So page 15 of the brief. Question. So as a lead investigator, if you lost evidence that you thought was important to your investigation, would it not behoove you to find out why? Answer, yes, it would. Question, but you didn't. And he responds, I spoke to the technical people who were in charge of that. Yes, I did. We actually even had a hearing.
Yeah, but look, I mean, that's why I couldn't find it, because I don't think that question invites it at all. I mean, the first part of his answer answers the question. The hearing doesn't seem to answer that question.
Oh, well, I mean, I think that it was not something that would have been discussed before. It was spontaneous by him, but I think he was defending himself from the attack by counsel that he didn't do his job. So this is what I did. And he only mentions a hearing. They don't know what happened at the hearing, the jury. The jury doesn't know what kind of hearing it was. The jury then got to find out, because he pushed one question too far. The jury then got to find out that there was no bad faith. They left it at that. I don't think that's improper. The jury was left with the correct impression.
Well, if defense counsel didn't push it too far, doesn't that kind of eliminate the argument you just made?
I'm sorry?
Well, if defense counsel did not invite this
Well,
answer
yeah.
about the hearing.
Well,
Then doesn't that eliminate the argument you just made about the rest of it being okay? Doesn't it all hinge upon defense counsel inviting that answer?
I wouldn't say it all hinges on it because I still think it's harmless error without question. I don't think that the jury got any impression other than this was poll footage that was lost, some kind of download technical problem. There may or may not have been a hearing. There was no bad faith. That's what the jury got from that. I don't think it's prejudicial. I don't think it affected its harmless error, if it's anything. And I also think it was invited by the defense and their line of questioning. I would hope this court would agree. I don't think that, I think that they just pushed it one question too far.
Didn't the state ask? So this issue with regard to the poll camera was previously addressed? Yes, it was. And was there any bad faith found by law enforcement as it relates to the, I'm sorry, was there any bad faith found by law enforcement? No.
Correct. That's what happened. It was in the co-defendant's case. This attorney knew darn well it was already raised.
I mean, it was a lot more than, the jury knew a lot more than just, hey, there was a vague hearing, right? The jury
afterward, they learned that, yes, it was determined there was not bad faith on behalf of the cop who was being grilled about his ineptitude.
And you're saying that's proper because the defense counsel invited it?
I do. I think it was an invite. And I also think that, like I said, the error is harmless. It's not, it doesn't give the jury the wrong impression about anything. It doesn't prejudice the defense or the state.
Well, wasn't it for the jury to decide if there was bad faith here? I mean, shouldn't that have been the jury's decision, not sort of telling them that a judge had already decided that in a different case? The
separate case should not have come into this if it weren't for the questions being asked about what happened with the poll camera and what the problems were. It should have never been brought up. Let's say this panel does not agree that defense counsel invited this. Okay. But the state was then allowed to go into the details of it, as I just read. There's error, correct? No, absolutely not. Okay, why not? I still believe it was the state was able to correct the impression. You can't mislead the jury. The jury would be left with a determined, or I guess with possibly with an argument that they didn't do their job on that poll camera. It was their fault that they lost it. I mean, isn't that the defendant's right to make that sort of argument? Isn't it the state's right to be able to correct that if there's a misleading of the jury onto that topic? Because it's been decided by another court. This is counsel, is there a difference between correcting it by saying, look, I looked into it, I asked the technical people, and we had our hard drives crash? That's an answer, right? It is. Then there's a separate answer of, oh, and by the way, some other judges already looked at this. Don't worry about it. There was no bad faith. Aren't those two different sort of responses? Well, yes, and those and counsel, one of them would have been better. One of them is proper. The first one's proper. I'm asking you, is the second one proper? I believe that it was in response to the way he was being questioned and the suggestion that he didn't do his job. Well, I think that's what the defense was trying to do. Why was it? Let's say this panel concludes that it was error. Okay. Why was it harmless? It was harmless error because the impression, again, that the jury was left with was a true and correct one, that there was no foul play on the part of the deputies found, that they destroyed evidence or they lost evidence other than negligence. There was no bad faith on their part. That's all that the jury was left with. I don't think that's being contested or challenged. I think that's true. I don't see how then, therefore, the error could be harmless for the jury to be aware of that. Wouldn't that have contributed to the verdict, though, when a issue is the credibility of the officer testifying? The officer testified he had no knowledge. He tried to back out of that in the earlier question. I don't have any technical knowledge of what happened. I was just told that the download failed. And the defense kept asking about it. It could have stopped right there. That's all he needed if that's what he wanted to do. But no, I mean, it is the truth. So the jury is left to decide with the real true fact evidence. We got one person saying they might have messed up. We have a state saying, well, there was no bad faith shown.
I mean, doesn't this bolster a law enforcement's testimony, at least to some degree, to say, look, yeah, and I mean, we're not talking about a regular witness. We're talking about a law enforcement officer, right?
Right, but we're talking about someone who they did lose the poll camera footage, so they're not that good at what they do. He's an expert. He's an expert in something else. He is not the technical guru, and he admitted as much. So what the jury would have learned, it's not bolstering his testimony. They know it didn't come from him. He's disavowed knowledge of the technical aspect, and his only was reporting what he was told, which is what the defense kept asking him. Well, wait, why didn't you do something personally? He said, here's what I did. I don't know anything about this stuff, but I went and did this and this. I didn't just sit down and, let be the case agent and let it go.
He might have investigated with his tech people, but he didn't hold a hearing, right?
He did not. This is true.
But that was brought up, and why? I mean, what's the point of bringing up the hearing and the fact that there was a finding of no bad faith? What's the point of that?
Well, there was no point of it, but the witness, you're left with the answer to the question that you asked.
Why did the state ask those questions?
Why did the state ask?
Yeah. Why did the state ask? Was there any bad faith by law enforcement? No, there was. That was done. To correct the tenor of the testimony that this person was that was inept. I mean, it was essentially to rehabilitate him, right, on this point.
But you're allowed to do that. How many sex abuse cases do we have that they're called a liar and the state can bring in?
Are you allowed to do that by referencing the findings of a judge in a different case altogether?
No, but he only referenced a hearing, and that's where it went from there. They didn't know anything about the hearing. They didn't know even if it was in this case or a different case. I don't.
Well, they knew that there was a finding of no bad faith.
Yes,
because the state brought that out, right?
The state did bring that out because the defense brought out that it was bad faith or suggested it. They would be able to argue freely that it was when everybody knew another court had determined it wasn't. Well, now why wasn't that the jury's job to decide whether there was bad faith? Well, how would the jury know about bad faith or good faith or whatever without that testimony? They would just think
the jury can't make the determination without knowing what a prior judge found in a different case.
Well, no, if the objection had been granted, we even had a hearing. Blank, that's it. So from there, I suppose either party could have argued, yeah, we don't know what happened in the hearing, but obviously there's bad faith. I don't know. I mean, that's where the objection was. And the jury is not aware that there was a full-blown hearing, but all the parties knew that. And I think the state had every right to correct that record so that there's no misinformation to the jury. This is, an attempt to go.
Counsel, moving to a different issue. What was the conspiracy? Who were the conspirators to sell Mdma? Well,
the ones that were named were various persons, including I think the Mdma was.
You had a phone call between, I think it was defendant and some unidentified buyer.
Okay, that one, right?
To purchase, to sell and purchase Mdma.
That was the Green Monkeys and Transformers call, right?
So what is that enough to support the charge of conspiracy between the seller and the buyer?
Well, there is plenty of case law to support appellant's position on that it's not a conspiracy, that you can't conspire. You're not in a simple buy-sell transaction if you're looking at it by itself. You can't conspire to buy and conspire to sell. That's two different things. All I can do is cite to the Schleicher case and argue that this wasn't just a sale. It's a sale and delivery. And like Hampton, I think it was the Hampton case that this court distinguished, where it was trafficking is different. In Schleicher, it was just charged with purchase or sale. That's it. It was one or the other. I can't remember. This is sale and delivery. Both of these, in the state's position, both of these parties could have been charged with delivery or conspiring to deliver drugs from one point to another. Schleicher, though, has the benefit. It mentions the Palin case and didn't go into it in too much detail because they didn't have what we have here. In this case, we have the MDMA conspiracy and we have the cocaine heroin conspiracy. And both of those, the purchasers testified that they purchased every day, nearly every day. This was an ongoing day in and day out where appellant in this case would be buying drugs in order to sell it to them. This was explained in the Palin case and suggests that in a situation like that, where you have those facts, you can sustain and support a conspiracy because there were enough parties involved to do that. That's the state's argument in that regard, that it can be a delivery, and that the Palin case cited in Schleicher supports it. Are there 30 seconds left? Are there questions on any other counts? If not, I would rely on my brief. Thank you, Your Honors.
Thank you, counsel. All right, counsel for the appellant. It looks like you have 4 minutes and 22 seconds. You may begin whenever you're ready.
Thank you, Your Honor. Specifically to address the concerns about the video, I think this court has agreed, at least appears to understand our position that it was not invited by the defense counsel. It was clearly a non-responsive answer to the question.
Let me follow up on that because the defense counsel does go on for 3 or so pages of the transcript. Basically, I mean, it appears to be insinuating that there was some bad faith on the officer's part in getting rid of this evidence. And then when one of the questions elicits the response that we had a hearing on this, then defense counsel says, yes, but the hearing was in a different case, and goes on and on. So when we're looking at this from an abuse of discretion standpoint, given the frequency of the questions regarding what happened to this poll camera footage and then defense counsel's comment that there was a hearing in a different case, why would no reasonable trial judge allow the question that the state was permitted to ask on redirect?
And so a couple of things. I don't think that it was the defense that brought up that it was a hearing in another case. The transcript that I have that's in my brief on page 8, the non-responsive question is, we actually even had a hearing about this for Chanel Roberts. And then the state brought up the issue on redirect, and that's when defense counsel objected and asked to approach. And the question that was objected to that the state asked was, you mentioned when counsel asked you that there was actually a hearing about this poll camera in the Chanel Roberts case. So I don't believe that was actually defense counsel who brought it up, that it was the state who referenced the other case. And that's when they
Counsel,
approached.
why wasn't it harmless though?
So I think it's not harmless because you have to look at Agent Noto's credibility was absolutely essential to this case, to the conviction of Mr. Hall, and that this improperly bolstered his credibility. This is an experienced law enforcement officer. He also blurted out early in his testimony that Mr. Hall was on probation, which was improper and objected to. And this defense chose not to ask for a curative instruction to draw attention to it. The state also improperly asked Chanel Roberts that she had no prior felony convictions. If you look at the pattern of testimony in this case, this was not just an inadvertent accident. And the state comes back to it in closing argument. And they say, come on, man, the police didn't lose evidence. They knew how critical Agent Noto's testimony in general was in order to convict Mr. Hall. So it's clearly harmful because it goes to the heart of this case, which is the credibility of all of this testimony linked to what we've argued previously and in our brief, the improper testimony about the generalized practices.
I mean, isn't there, but aren't the issues kind of separate, right? I mean, let's say that we disagree with you on the admissibility of most of his expert opinions, right? Especially interpreting the code and things like that, the code language. I mean, isn't the poll camera video and it's the fact that it's missing kind of separated from his credibility as to interpreting the code of drug deals?
I mean, I certainly think we believe certainly, and that's why we separated the argument, standing alone, this improper testimony about the poll cam footage would be in and of itself reversible error for this court to reverse. So I think it can be seen as separate.
But what I'm saying is that it maybe bolstered his reason for not having the footage, right? But did it bolster all of his other testimony that, hey, look, I've listened to, thousands of hours of calls, and this is what this code means?
Yes. I mean, I think the answer is yes, because here we have no way of knowing what did or did not happen at Mr. Hall's house without this footage, right? Other than his testimony. So the jury has to rely on his testimony and his credibility that he's telling the truth and that he saw what he in fact says he saw before the poll cam footage was destroyed. So I think they're very, very linked to one another. I see that I'm taking down very briefly again, with respect to the jargon, there were inside witnesses, co-defendants, and 2 buyers, none of whom were asked about the lingo, none of whom testified about it. These sale of food stamps, stolen laundry detergent, these are all uncharged crimes, prejudicial information that was before the jury. And this testimony, again, far exceeded the bounds of relevant admissible testimony. The state used this speculative, improper testimony to try to nudge their case across the reasonable doubt threshold. The error was harmful, directly led to Mr. Hall's convictions and sentences, and we're asking this court to reverse.
Thank you, counsel.
Thank you.
And with that, the court will be in recess.